think we could probably go ahead and get started, at least with the introductory stuff. People will probably continue to join in as they get out of class. Welcome. Thank you all for joining. Thank you, Justice Earls, for making the virtual trip to Michigan. Honored to have you here and to discuss this case and kind of what's at issue in it, and what's at issue more broadly. So just for quick introductions for those who aren't familiar. So Anita Earls is an Associate Justice of the North Carolina Supreme Court. Before taking office on January 1st, 2019, she was a civil rights attorney litigating voting rights and other civil rights cases for 30 years. Justice Earls was the founder and executive director of the Southern Coalition for Social Justice, a nonprofit legal advocacy organization in Durham, North Carolina. And in the Clinton administration, Justice Earls served as a Deputy Assistant Attorney General in the U.S. Department of Justice in the Civil Rights Division, and has served on the North Carolina State Board of Elections and the North Carolina Equal Access to Justice Commission. So very well qualified to talk on the topic. Justice Earls is taught as an adjunct professor at UNC and University of Maryland Law Schools and in the African and African American Studies Department at Duke. And Justice Earls graduated from Yale Law School and Williams College. And our second speaker is Professor Jon Weinberg from Wayne State. He's a professor of law and the inaugural Associate Dean for Research and Faculty Development at Wayne State University here in Detroit. Professor Weinberg has been a law clerk to Supreme Court Justice Thurgood Marshall and then Judge Ruth Bader Ginsburg, a visiting scholar at the University of Tokyo's Institute of Journalism and Communication Studies, a law firm associate in Washington, D.C., a professor in residence at the Justice Department, a legal scholar in residence at the Federal Communications Commission, and a visiting scholar at Cardozo Law School. He has published articles on a wide-ranging set of topics, including privacy, internet law, immigration and citizenship law, and the First Amendment. And Professor Weinberg graduated from Columbia Law and from Harvard University. So thank you again both for joining us. I'm really excited to hear what you have to say on this. So as just a quick introduction for those who aren't familiar, this is the case that we're discussing today is coming out of the Florida constitutional amendment from 2018 to re-enfranchise formerly incarcerated individuals. And it's in the implementation of that process that we'll just say some changes have been made and challenges raised because of those. So with that, I'll hand it off to Professor Weinberg to go into a bit more depth on that and tell us what's going on. And yes, thank you again, both.
Okay. Well, thanks so much. I just want to say to start out that I am hugely honored to be sitting here for some value up here. Hugely honored to be sitting here with Justice Earls, whose career and accomplishments so far have been amazing, whose work is not by a long shot done, and I cannot emphasize this enough, who knows much more about voting rights law than I do. So in general, on this panel, you should be listening to her and not to me. That said, the organizers asked me to kick us off by just sketching out the larger Jones-DeSantis litigation, which has a lot of moving parts. So I'm just going to try and work through that so we've got some common backgrounds. Since 1845, Florida law has provided that people convicted of felonies lose their right to vote. In 2018, the people of the state of Florida, by a vote of almost 65%, passed an amendment to the state constitution under which, with some exceptions, and I'm going to quote here, any disqualification from voting arising from a felony conviction shall terminate and voting rights shall be restored upon completion of all terms of sentence, including parole and probation. So you get your voting rights back upon completion of all terms of sentence, including parole or probation. And this promised to restore voting rights to over 1 million people. Following year, though, Florida state legislature enacts a law providing, among other things, that completion of all terms of sentence language meant that the state would not restore a felon's voting rights until after he or she paid off any fines, fees, costs, or restitution associated with the conviction. The jargon for these as a group is legal financial obligations, or LFOs. Later on, the Florida Supreme Court holds that even without regard to the statute, it would interpret the constitutional amendment as requiring the same thing. That's really consequential. Number one, more than 3/4 of the people convicted of felonies in Florida who have served their sentences owe some kind of LFO. And of those people, the overwhelming majority cannot pay off those obligations, which are substantial, because they're poor and they don't have the money. Second, even if they can pay, most people convicted of felonies in Florida have no good way of telling whether they owe any money in LFOs. Third, even if they do know, in lots of cases, it's impossible to tell how much money a person might be deemed to owe in LFOs. The records commonly are missing, commonly are internally contradictory. Florida's set up no way for a person to get at them, even if they exist. Now, you might think it would be Florida's job to set up a process that would generate a ruling by the state under which a particular person convicted of a felony is, in fact, eligible to vote under state law. And Florida has a process like that on paper, but so far it's generated exactly 0 rulings, with 85,000 filed voter registrations waiting in the pipeline for those rulings. In the meantime, even though the people who have filed those voter registrations have the power to walk into the booth and cast votes, they mostly, in fact, aren't doing that for the very good reason that they're worried that the state could rule after the fact that they weren't eligible and had committed a crime by voting illegally. District court finds all of this unconstitutional on multiple grounds. First, it says once the state's granting some former felon's reinstatement, it's unconstitutional for it to deny it to some people, solely on the ground that those people are too poor to pay off their LFOs. Second, it holds that because the LFOs include flat fee court costs that are assessed against every convicted defendant as a way of financing the court system, they should be deemed a tax. And that means that requiring their payment as a precondition of voting violates the 24th Amendment as an unconstitutional tax, paying a tax as a precondition to voting. Finally, it continues, the fact that the state's made it illegal to vote without paying off your LFOs, but has provided no adequate means of telling whether or how much you have to pay looks like a due process violation. State appeals to the 11th Circuit. 11th Circuit reverses ruling for the state of Florida across the board. Court sits en banc, divides 6-4. Says the fact that people were too poor to pay off their LFOs was not a problem because, any discrimination against those who are too poor to pay should be judged only by rational basis analysis, and it's justified by the state's interest in making sure that nobody gets to vote unless they fully paid off their debt to society. Fees weren't poll taxes or otherwise taxes unconstitutional under the 24th Amendment because they were assessed only against those convicted of crimes. And there's no procedural due process violation because, says the state, here I'm going to quote here, states are constitutionally entitled to set legitimate voter qualifications and to require voters to comply with those laws through their own efforts. All right, almost done here. Plaintiffs do raise a couple of additional arguments. First, they argue that the statutory components of the LFO rule should be struck as the denial of the right to vote on the basis of race. Because, no one could have failed to notice that the people whom the LFO requirement excludes from Florida's political process are disproportionately Black. District Court rejects this claim, even though it says it thinks it's a close issue. And the court concedes that, there was, some reason to think that the Republican legislature had enacted the statute because it recognized that the people it was excluding were disproportionately Black, had concluded on that basis that they vote disproportionately Democratic, and had therefore said, well, let's come up with a statute that will keep those people from regaining their voting rights. But it concludes, nonetheless, that there wasn't sufficient basis for a finding that the legislature was motivated by a desire to disenfranchise Black people. And plaintiffs finally make one last claim. That's the one that's still pending, in fact, before the 11th Circuit, that's highlighted by the organizers of this panel, which is they say the LFO rules amount to discrimination against women. Because women released from prison after serving terms for felonies are especially likely to be poor and unable to pay off their LFOs and therefore excluded from voting. Now, you'll notice here there's no claim of intentional discrimination. Plaintiffs aren't saying that anyone enacted this rule with the goal of disenfranchising women. Their argument rather is that in this context, subjective intent shouldn't matter. It should be enough, therefore, rather, that the rule has a disproportionate impact on women as a group, and therefore, they say, subverts women's equal citizenship. District Court doesn't rule in plaintiff's favor on that claim, it rejects it, and that's the issue currently pending for decision before the 11th Circuit. And with that as background, you guys know everything you need to know. And so I'm gonna kick it back to Stephen, who is muted.
Yeah, so thank you for that. As everyone knows, or as everyone understands now a little bit better, there's a lot going on with this case. And so I guess there's a few things that, a few ways we could take this, but I guess Justice Earls, I'd love to start with you and just ask, like, from my understanding of the history of voting rights, the 19th Amendment hasn't been a frequent source of major contention. You know, like there's not the famous cases. I took election law last semester, and I don't think we even really discussed it. You know, like it doesn't come up that much. So how notable is this in that regard? Have you ever done any work in your decades of working on this on the 19th Amendment? And if so, like what did you see with this case when you saw it, and what's there most important to pay attention to? And just talk to that in any way that you see fit.
Well, thank you so much, and thank you for the kind introduction and those kind words about my background and experience. I really appreciate this opportunity to talk with all of you. And I'll say one surprising thing about becoming an appellate judge after being a litigator for 30 years is how hard it is to be kind of isolated. So this is I just love seeing your faces and having the chance to interact with you, and I really will welcome your questions and discussion. I do want to say a couple of quick words about my background with litigating voting rights cases in Florida, because it's somewhat relevant to this case. So I represented the NAACP in litigation in Florida in 2000 after the 2000 Bush v. Gore, well, how do I say this non-pejoratively? After all the things that happened in Florida in the 2000 election. And the fact that Florida disenfranchised people with felony convictions was relevant in that case, because a lot of people without felony convictions got knocked off the voter rolls because of the way Florida did its database matching. So when it took its list of registered voters and its list of people with convictions, they had very loose parameters. So so matches came up that were false positives. So people came up and they came up as matching, their voter registration was deleted, and it wasn't them. But I learned a lot about database matching in the course of that litigation, but also how the felon disenfranchisement laws were being administered in Florida in a way that impacted not only people with felony convictions, but other voters as well. And that actually disproportionately disenfranchised Black voters, because their names more often were the false positives. Black and Hispanic voters in Florida, their names were more often the false positives. The other piece of litigation in Florida I was involved in was Johnson v. Bush, the case that challenged Florida's felony disenfranchisement laws as being intentionally racially discriminatory. And we lost that case in the 11th Circuit. I was at the Lawyers Committee for Civil Rights under law at the time, and the Brennan Center were co-counsel. So I didn't argue that case en banc in the 11th Circuit, but I was there for the argument. And I think that some of the evidence in that case around Florida's 1868 enactment of this ban was just some of the most stark and direct evidence of racial intent you can imagine. There were state legislators saying, you're going to be so proud of us for putting this in place because we are going to keep Blacks from voting. And I'm cleaning up, I'm sanitizing their language, but it was very direct and very stark evidence of racial intent, so that it raised the legal question of when Florida reenacted this provision in 1968, did the discriminatory intent carry over? And the court, we tried to use precedent from the education, Fordyce versus Mississippi, from the education law arena to say that, you know, you can't just reenact a new provision and say, okay, this time we're not doing it for racial reasons. But the court didn't go there with us in that case. So then to get to the question of the 19th Amendment, no, I have never brought a 19th Amendment claim in any case that I've litigated. But what I first thought of when I saw that this was a claim in this case was the fact that in litigation challenging North Carolina's, what was called by advocates here, the monster vote suppression bill in 2013, that was passed by the North Carolina legislature right after the Supreme Court decided that Section 5 was unconstitutional. In that case, there was a 26th Amendment claim, a claim that the legislature's decision to end pre-registration of 16 and 17-year-olds was discriminatory against 18-year-olds in violation of, it made it harder for them to register. And there was evidence at trial from a professor about how pre-registration really facilitated young people registering and voting. And the court agreed with us and found that there was a 26th Amendment violation. So I raise that to say that just because it hasn't been litigated in the past doesn't mean that the legal theory isn't sound or that it couldn't get traction. I think given the logic of the 11th Circuit's handling of the other claims in this case, there might be cause for caution and concern, but I think what it should turn on are the facts. And if the plaintiffs have the information, if they have the data to show that this is having a disproportionate impact on women, then it seems to me that it's worth considering. And I'll say, in some of the voter ID litigation, there was definitely evidence that women disproportionately did not have driver's licenses in a name that matched their name on the voter rolls. And this is, I think, in large part because when women change their name, either through marriage or divorce, they do change their driver's license, but they don't think to change their voter registration. And so women were disproportionately impacted. Just if you look at whose names didn't match, whose driver's license name didn't match their voter registration. But I don't think that there was an effort to bring in the 19th Amendment there. And so, you know, maybe that was a missed opportunity. But I think that there are interesting ways in which voting laws interact with gender. There's been some effort to look at whether redistricting, whether the way districts are drawn, and whether the way there are sometimes concentrations of single family or single parent female-headed households in urban areas could result in districts that concentrate women more so and therefore dilute their voting strength. But I'm not aware. So there's been talk about that amongst voting rights advocates. I'm not aware of any case that's been brought along those lines. But those are sort of my my initial thoughts about the 19th Amendment and this litigation in Florida. And I'd love to hear more questions and discussion.
Yeah, so with that in mind, anybody wants to add questions to the chat, we can bring those in, or if you want to raise them directly, just raise your hand and we'll go from there. One question that I really had with this that gets at that intent issue is or the disparate impact, I guess more specifically, is this is a really unique kind of combination of things. So kind of conflicting impact, I guess you could say. I think the appellant's case is that the rate at which this happens for women is disparately large, but at the same point, the overall number of people affected is actually, more men are affected by this change. I think was what the opposing counsel raised in response to that. And so how do you see, like, what have courts done with that before, if the disparate impact could be kind of framed in two different ways, like that? Like, it seems like this, if you take the universe of people who have been incarcerated and are trying to return to voting, the rate of women being affected is greater. But if you just take the overall number of people amongst the population, the rate of men is greater, I think. How do courts tend to take that into consideration? How do you see that going in this case?
So I think in discrimination law generally, there are some types of claims where the overall numbers matter, but I think in terms of voting, so I'm thinking about employment discrimination cases, for example, but in the voting context, I'm not sure that if you're, so we make a distinction between vote denial, where you're just not being able to vote at all, and vote dilution, where you're voting, but your voting strength is weaker compared to some other group in the population. And on the vote denial side, I don't know of any theory that says numbers matter, and that it would be okay to deny the right to vote on the basis of gender, or to a few people, to a few women, but that you'd have to have enough to impact the outcome of the election, or you'd have to have enough that reach some threshold. I mean, there aren't that many cases, but I have seen cases from, and these are a little bit older case, but where a polling place official at a particular precinct said to a single Black voter, "I'm not letting you vote here because I know, because you're Black," basically, like straight out discriminatory intent, only impacted one voter. That was still a violation of the Voting Rights Act, and I would argue a violation of the Constitution. So that's a long-winded way of saying, even if numerically more men are disenfranchised by this law, if it's having a disproportionate impact on women, it seems to me that that's not something. I mean, so you do also have to get over the hurdle of understanding discrimination as being captured by disparate impact, and that our Constitution should be broader than just the model of a single bad actor who has bad and discriminatory intent, but that laws can interact with social conditions to ultimately discriminate. And I'll just put a footnote. I think I'm right that the rest of the world does understand discrimination to occur when there's disparate impact, and so international codes and other legal systems don't require proof of a discriminatory intent in a single bad actor. But assuming you get to that point under the 19th Amendment, it doesn't seem to me that it should matter whether it's a few women or a lot of women. If you're being impacted because of your gender, that should not be permitted by the Constitution.
I'm going to jump in here for a moment just to explain why the disparate argument under existing doctrinal law is a bit of a heavy lift here. And the reason is that in general, the Supreme Court, when it's ruling purely as a matter of constitutional law, has been pretty hostile to disparate impact arguments in the context of discrimination claims. So we got the early claim of Washington against Davis, where the issue is, well, if a state enacts a rule that's not shown to have been motivated by a desire to discriminate against Black people, and doesn't actually draw racial lines, but nonetheless has that disparate impact, are we going to treat that as a racial classification subject to strict scrutiny under the Equal Protection Clause? And the court says no. The court says, no, we don't care about disparate impact. Disparate impact is not our problem. It's just something that, happens out there in the world. Life is tough. We're going to limit this special Equal Protection Clause scrutiny to cases where this distinction actually either explicitly draws a racial line or is motivated by the desire to discriminate against a racial minority. Come to the Feeney case, court says just about exactly the same thing. Indeed, goes a step farther when it comes to gender claims. Says if a rule doesn't explicitly treat men one way and women another way on its face, then we're going to treat this as a gender classification subject to heightened scrutiny. Only if the legislature enacted this law with the goal of basically hurting or disadvantaging women. You get a case like Mobile against Bolden, which is a voting rights case. And the question, are we going to treat this voting rule as subject to higher scrutiny? Once again, because of its impact on lessening the voting power of Black citizens. And the court says, no, we're not going to look at disparate impacts. Instead, we're just going to ask, was this motivated by that impermissible desire? And with all that as background, that makes this argument by plaintiffs a much heavier lift than it would be otherwise. Because if they're saying, well, in fact, this law should be struck because it's as a matter of constitutional law, because it has a disparate impact on women, the court's going to want to say, well, what about Mobile against Bolden? And if we say, well, in fact, Mobile against Bolden was probably wrongly decided from the get-go, which I think is a very substantial argument. That's not necessarily going to be an argument that the Supreme Court, and in particular this Supreme Court, is likely to be sympathetic to. So there is that problem.
Oh, Andrew, go ahead.
Yeah, so thank you for being here, Justice Earls. I wanted to ask a question that's somewhat political, but we don't need to make it entirely political with the purpose of alienating people. But I did have, a question about, the fact that North Carolina, your state, has a Republican state House, has a Republican state Senate, and the only line of defense from Republicans passing whatever, legislative Democratic reforms they want to is currently the governor. And he'll be up for re-election in 2024, so that'll be a while from now. But I'm curious as to what you think about, are you concerned about the potential, if the governor's seat were to change hands in 2024, what the next decade of state issues in democracy may be, and what role you think the Supreme Court would have in that?
Well, that's an interesting question. I think that in general, the courts have it's kind of been a mixed bag in terms of the times at which the courts have stepped in to protect voting rights and the times at which they have stepped back. And so what I do think is that the politics of who is advantaged and disadvantaged by some of these measures might also change. So, for example, it is true that during the pandemic in 2020, we saw some differential rates of who used early voting versus who voted in person on the day, but that is not necessarily static. And so I think that could change. And so I think the efficacy of various changes affecting voting can also change. And I'll just say, in North Carolina, when I was running for this court, for this seat, the General Assembly actually changed the law 5 times to try to impact the outcome of my race, and it backfired, obviously. But I think I'll say a couple of other things about the role of the courts. There's also the bill in Congress, right? That would, so the For the People Act that has been passed by the House would eliminate this entire disenfranchisement in Florida for federal elections. And we previously had an experience of a law being passed for federal elections and states only wanting to implement it for federal elections and do something different for state elections. That was the NVRA. Like, believe it or not, it was actually controversial to think that you ought to be able to register to vote when you get your driver's license. And the state of Mississippi didn't want to allow its voters to do that. So they were going to have they established 2 separate voter registration systems. And ultimately, that was finally ended through federal litigation under the Voting Rights Act because it was having a discriminatory impact on Black voters to have these 2 separate voter registration lists. But I just say all that to say, if we do get a federal law that regulates these issues for federal elections only, it will be interesting to see the extent to which state laws could then come into play and try to have a different regime. But I think that's about all I can say about what might happen with legislatures and courts.
I have one follow-up question on that. So with the distinction between federal and state registration, so my understanding with a lot of this is that, like, it's the federal requirements often get kind of incorporated into the states merely for cost reasons because it's expensive to do 2 systems. Did that happen there? Did they run separate, did they have separate ballots for state and federal elections? Like, how did they do that, and why did that work there? I guess at least until it was challenged, and why was it challenged, or like how did that challenge work successfully?
So I don't know as much as I should about that litigation, but what I know that Mississippi had 2 separate voter registration forms and 2 separate voter registration rolls, and whether they had a single ballot and only counted the federal offices for the people who came to the polls and were only registered as federal voters, I actually don't know. And I also don't know to the extent to which there might have been injunctive relief early on, so that there wasn't a whole lot of experience implementing this dual registration system. But I think it just, it's kind of the unique structure of our system that Congress feels or is limited to regulating federal elections, and state elections are still within the state jurisdiction.
That was an instance where Mississippi was willing to go to a great deal of extra trouble and expense in service of the goal of excluding Black voters from state elections.
Okay, yeah, and if I recall correctly, Mississippi was the state that also just had the essential, they just repealed or changed something that I think had been in their state constitution in terms of the kind of, you had to win every county in addition to every, I'm sorry, I'm speaking from memory, and I don't remember for sure if that's what it was, if that was the exact setup, but I'm pretty sure it was, but that's getting a little afield. Sorry. Andrew, did you have another question?
Well, I just wanted to comment. I think the Mississippi rule is that it has to do with their state house districts, which is also worse
that
because of legislative districts. Yeah.
Thank you. So, Justice Earls, if you could speak a little bit more about, well, so you mentioned before you think there's cause for concern with the 11th Circuit. Could you tell a little bit about why you think there is that cause for concern, and like, how do you think this is going to go with this last remaining challenge, because I think I got the impression that this was kind of the least strong argument they had. So, and they've lost on the others. So, like, could you speak a little bit to how you think that will play out with the 11th Circuit specifically?
Well, just reading the 11th Circuit opinion, I thought the dissent, I was struck by, I thought it was a strong dissent, but the sentence, the majority proceeds as though the reality on the ground doesn't matter. That's a pretty, now as a judge, that's a pretty strong thing to say in your opinion. And as an appellate judge now, we do take seriously and understand that the trial courts are the fact finders. So in this case, you had a significant trial, you had a significant opinion making findings of fact. And I think the dissent is right, that the majority, you wouldn't even know that reading the majority opinion. You wouldn't even, and some of the facts are pretty compelling, that the state of Florida couldn't even tell the plaintiffs in this lawsuit how much money they owe, so that they couldn't even be able, that kind of gets into some of the due process basis for this overturning this statute, but it is pretty stark for the state to set up a process. 85,000 people try to register and they haven't processed a single one of those registrations. That's strong and compelling evidence, and yet it was just the majority was unfazed. And contrast that with the complete lack of evidence, in my view, of the basis that was supposed to be the rational basis for this state law. So the majority upholds, under the equal protection analysis, upholds the law because it was reasonable for the legislators to assume that people who have paid their fines would be more responsible citizens than people who have not. So I looked at, okay, what's their support for that? Because when I'm writing my opinions, I usually try to have some support for what I'm saying. If it's a factual matter, it ought to be in the record. It ought to be a finding of fact of the court below. If it's a legal proposition, I should find a case or something that supports it. And the citation there is to a case out of the Second Circuit, which similarly made some generalized statement about it's okay for the legislature to, and that case cites John Locke, cites political philosophy for the notion that it's okay for the legislature to assume that that people will be more responsible citizens, and I'm not 100% sure how you may or may not prove that as an empirical matter, but what I do know is that the right to vote really does matter to a lot of people, and it means a lot to them in terms of them being a member of society and sort of regaining their status after a conviction. And I'll just give you one little anecdote on that. When I was at the Justice Department, the Attorney General at the time, Janet Reno, from Florida, she had this practice of going out to the public and saying, when she would be addressing the public, she'd say, okay, if you were the Attorney General, and you could wave your magic wand and do anything, what would you do? So she was speaking to a group called Youth Build, which is a program that works with juveniles in the juvenile justice system. And some of these folks get convicted of crimes under the age of 18, and then they never got to vote, and they never will be able to vote unless these restrictive laws are changed. And one of the young men in that Youth Build program said, well, if I was the Attorney General, I would make it possible for me to vote. And to think of all the things he could have said the Attorney General should do, and that was what was important to him, I think really demonstrates, it's an anecdote, but I think it demonstrates that it really does matter to people. And I can't imagine any rational relationship between how much money you have and whether you can figure out what fines and fees you owe and pay them, and the extent to which voting matters to you, and that you should have a voice in our democracy. So That's a long-winded way of saying that even if the evidence is compelling about this, the impact of this on women, the impact of this disenfranchisement, and I do think that there are important ways in which criminal convictions impact women differently. So one of the things I've been able to do as a justice is serve on a task force that our governor appointed, a task force on racial equity in criminal justice. And we heard from advocates around the state about how North Carolina is a state that doesn't opt out of the federal disqualifications for SNAP benefits if you have a conviction. So women come out and can't really support their families because they can't get the benefits that otherwise they would be entitled to based on their income. And so here, even if the evidence was compelling about the reasons why women should be able to participate in our democracy and get their rights restored, it's not clear that the 11th Circuit would be compelled by that, based on how they've decided the case so far.
I'm gonna add one thing to that, which is that I spoke before of ways in which I thought plaintiffs were swimming upstream against the tide of the case law when it came to the intent versus impact issue. I think one way in which they're definitely not swimming upstream against the tide of the case law is when it comes to the essentially conceded, agreed upon effect of this law on poor people. It is completely conceded that of the 1 million+ people who we had thought were re-enfranchised by the amendment to the Florida State Constitution, under this ruling, most of them will never get to vote. And the reason they will never get to vote is because they're poor. And there is, in fact, a pretty significant amount of Supreme Court case law to the effect that the state can't simply deny people the benefits of equal citizenship because of their poverty. Poverty is the cause in this society for not getting a variety of things, causing the society for means of being deprived of all sorts of material goods. But the state court has said, I think more than once, doesn't get to say you don't get to vote because you're poor. And yet that's in a very straightforward respect what's going on here. And it's the 11th Circuit not agreeing with that proposition. I could go on and on about positions the 11th Circuit has taken in a wide range of cases. But it's the 11th Circuit not agreeing with that proposition that leaves one with not a lot of hope that they're going to come up with progressive views on less straightforward ones.
Okay, Emily, I see you raising your hand. Go ahead.
Yes, I can't raise my virtual hand, so I'm raising my physical hands. I was wondering, you've both talked a lot about the 11th Circuit and their sort of disposition towards this issue and how they've made that clear. Do you think that this case or any of the previous legal arguments made in Florida could lead to new or renewed litigation in other districts or circuits that have a different disposition for felon re-enfranchisement, essentially?
So there aren't that many states left that disenfranchise even beyond release from custody or serving your probation and parole. I am interested. I do think it's an interesting question, the impact of this en banc decision on the 3 lawsuits that have just been filed in Georgia, challenging the new law that was passed in Georgia. And I don't know I'm not up on all of the legal theories that were brought in those cases. I do think that there were certainly some race discrimination claims. The issue of felon disenfranchisement has been litigated in numerous states, and it was fairly well determined that you can't bring a Voting Rights Act claim, right? So Section 2 of the Voting Rights Act is the permanent part of the act that says you can't have a practice or procedure that discriminates on the basis of race. In every state, a law that disenfranchises based on having a felony conviction will have a disparate impact on people of color. So Washington State, for example, in the case of Farrakhan versus Locke, had really compelling evidence about how Black voters in Washington State were disadvantaged by discrimination in the criminal justice system. And ultimately, the courts have said that you can't have, the Voting Rights Act can't outlaw felon disenfranchisement because it's passed pursuant to the 14th Amendment, which itself contemplates that felons could be disenfranchised. So it's kind of a conundrum, but this new law that that the House has passed would achieve this for federal elections throughout the country.
It's worth thinking about where some of this comes from, which is that the question comes to the Supreme Court in 1974 in Richardson v. Ramirez, whether felon disenfranchisement laws are constitutional in the first place. If the Constitution mandates careful scrutiny of state rules that just take whole classes of people and deprive them of the rights of citizenship, deprive them of the right to participate in the political process, how do we justify a rule that just makes this blanket rule? If you've been convicted of a felony, that's it, you're done, you're out, potentially for the rest of your life. And the Supreme Court majority says no, this is constitutional on a blanket basis, because at the time of the enactment of the Reconstruction Amendments, most states had felon disenfranchisement laws, and indeed the text recognizes that states might want to deprive people of voting rights for participation in rebellion, or the text says, or other crime. The real motivation there is that in the Military Reconstruction Act of 1867, in fact, Congress had said that people who had held federal or state office before the Civil War and then participated in insurrection were deprived of the right to vote. And the drafters of the 14th Amendment, of the 15th Amendment didn't want to mess with that. No, 14th Amendment. Drafters of the 14th Amendment didn't want to mess with that. But, Marshall and Brennan dissent there. And Justice Marshall writes, well, just because felon disenfranchisement laws were accepted in 1868 shouldn't necessarily mean that we see them as constitutional now. That, if we understand ourselves to have an evolving and improving standard of what, equality maintains, what equality requires, we ought to be taking a second look at whether felon disenfranchisement laws really are consistent with what constitutional equality means today. And they lose that case, but it's the 1974 Richardson against Ramirez ruling that makes it really easy for the 11th Circuit today to say, well, does it really matter what happens to all these people? Because, hey, they're just felons. They don't have constitutional rights anyhow.
Yeah, I remember thinking about that very question in my election law course, where the discussion about the disenfranchisement in the 14th Amendment seemed very clearly pointed at the Civil War. And it seemed like we're talking about very different types of felonies in the 20th and 21st century in the United States than what they had in mind there, but it doesn't seem like that ever evolved. So my question from that would be, unless I don't want to be blocking anybody. Okay. So my question from that would be, what do you see as a path forward for ameliorating that? Like, does HR 1 get there if it passes? Like, does that kind of establish a more uniform equality in terms of access to voting, or is it just a small step and much more needs to be done? If more, what does that look like? Yeah, like one of the things that I'm taking from this moment is that there's a lot to be done. There's a lot at both the state and federal levels, and I don't know what it is. And so I want to try and figure that out. So Justice Earls, go ahead.
So I think that it is a good step, but it doesn't completely address voting rights for all elections. So there's certainly those who advocate for a constitutional amendment that would establish a right to vote generally, and not have all these constraints. So I think so I will also say that almost every state constitution has some mention of a right to vote. In North Carolina, it's not particularly explicit. It says all elections shall be free. So think about state court litigation under state constitution. And that certainly happened with the voter ID requirement. So in some states, I want to say Arkansas, in some states, the state's Supreme Court found that their state voter ID, that the voter ID provision, a voter ID provision, violated the state constitution. That varies state by state. We had a constitutional amendment in North Carolina that established a voter ID requirement. So it's a double-edged sword to look at states, but state constitutions can be a rich source of protecting rights in some states.
I think we're going to be having that discussion in Michigan very, very soon. I've seen talk of proposals in the legislature that are almost certainly, or very certainly, will be vetoed by the governor. But there's already talk of how to get around that and how that might conflict with our own Promote the Vote amendment in 2018. But yeah, I want to say, are there any other questions? I know we're running short on time, so I want to be respectful of that. Okay, well, if that's good, I don't have any others at the moment that I think are urgently pressing. So I want to say thank you both for joining. This has been really useful, and again, it's been very, very much an honor and a pleasure to have you here. So thank you to Justice Earls and to Professor Weinberg, and thank you for everyone else for joining in. I hope it was all worthwhile. And yeah, that's all I have.
Thank you.
Well, thank you all. I really enjoyed this opportunity.
Thank you.